Hello, Judge. I would like to begin by reading out a statement. This hearing is in the matter of CFI 054-2018 before Lord Justice Angus Glennie and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Denton & Co. Lead counsel is Gregor Hogan. The first defendant is not present. The second defendant is not present. The third defendant is represented by Evershed Sutherland International LLP. Lead counsel is Thomas Pluman QC.
Thank you very much. Mr. Hogan, it's your application, I think.
Yes, my lord. Good morning. As your clerks just indicated, I appear on behalf of the claimant, who I'll refer to.
I'm sorry to interrupt, my lord. I, for some reason, seem to be receiving sound from you, and I understand that I can be heard, but I'm not receiving sound from anybody else. I may have to log off and log on again.
Yes, do you want to do that? You can't hear Mr. Hogan, is that right?
Yes, I seem not to be. I heard Mr. Page when he spoke. I can't hear Mr. Hogan, and I couldn't hear Mr. Ahmad.
Right, well, do you want to try and log off and on again, and we'll wait for you?
Yes, I'll do that. Thank you very much, my lord. I do apologize. I've rejoined. I wonder if Mr. Hogan could say something.
Good morning, Mr. Pluman. Can you hear me?
No, that is very odd.
Still can't hear?
No, I'm afraid I'm still not getting it.
Mr. Thomas, is it you can hear me? I don't think so.
It's Mr. Pluman. Was that Mohammed speaking?
No.
No, that was
I'm going to try one more time. I wonder if Mr. Hogan would try again.
Morning, Mr. Pluman.
My lord, I can now hear Mr. Hogan, and if I can still hear your lordship, that probably is all that matters.
Well, can you hear me?
Yes, yes, I can. I do. I don't really understand why it's.
Well, it usually happens with me who has to log off again. And so hold your hand up if you can't hear, or interrupt if you can't hear at any point.
Yes, thank you very much.
Thanks. Sorry for this inconvenience. Sorry.
No worry, it happens all the time. It's not your fault.
Thank you, my lord.
Thank you.
Thank you. As your clerk indicated, I appear on behalf of the claimant, who I'll refer to as SBM. Mr. Pluman, Queen's Counsel, appears with Mr. Page on behalf of the third defendant, who I'll refer to as Prime. As your clerk also indicated, the first and second defendants have confirmed to the registry this morning that they won't be attending. That's been the case for some time, but that's now been confirmed. Before I begin, can I just confirm that you've received 3 hearing bundles S, T, and U?
Yep.
And you should also have received a skeleton argument from myself and also from Prime.
Yes, I have. Thank you. I've read the skeleton arguments. I've read some of the documents in the hearing bundle, but not everything. But you can take it I'm reasonably familiar with the issues because I dealt with the matter some months ago.
Yes, I'm grateful, my lord. Perhaps at the beginning I should say that I think that some of the issues in terms of the substantive applications that SBM is seeking have somewhat narrowed in light of what I'll describe as preemptive compliance with the draft order by Prime and Mr. Sadder. So I'm hoping that should mean we need to take up less time than perhaps was initially thought.
Can I just emphasize, we only have 2 hours set aside. If we go beyond that, we'll need to refix for tomorrow morning or something like that.
I'm grateful because my diary had been updated to move it forward by an hour and add on another hour. So that's very helpful for that indication, my lord. Thank you.
Right.
My lord, there's 2 applications before you today. There's SBM's disclosure application, and there's also an application by the first and second defendants, RENISH and Mr. MEHTA, to adjourn the trial, which is listed for the start of October.
Yes.
It would be my intention to deal with the disclosure application first. However, I'm happy to start with the adjournment application if you would prefer.
But it seems to me on the adjournment application that in the absence of the first and second defendants from this hearing, and subject to anything either of you may wish to say about it, that I should refuse that application. The Scottish expression, which I'm more used to now, is in hoc statu, which means on the state of the evidence as at present. The reason for that is that there is no sufficient evidence, it seems to me, on behalf of the first and second defendants as to why the funding which has been available to date can no longer be obtained. That's from the third-party funder. And so far as concerns access to funds in the banks which are subject to the worldwide freezing order, there's no adequate evidence as to what the problem might be, if there is yet a problem, or whether it's simply a suspected problem in drawing funds from those accounts. The exception to the freezing order allows reasonable sums to be drawn from the accounts on notice, and there's no basis, it seems to me, at the moment for saying on the evidence that that is incapable of being operated. So unless either of you want to say anything about that, I would propose to write something to that effect when refusing the order, allowing, but by making it clear that it's on the present state of the evidence, I refuse the application. It leaves it open if there's a real problem that needs to be addressed for some renewed or varied application to be made in the future.
My lord, I think you've encapsulated my submissions, which were going to be that the application should be dismissed on procedural grounds because it's far too late, but also on the substantive merits because, there, as your lordship has indicated, there is, in my submission, a paucity of evidence supporting the alleged impecuniosity of the first and second defendants. But
well, unless Mr. Pluman wants to either disagree or add anything I said, that's how I would propose to deal with it, and then we can concentrate on disclosure. Mr. Pluman,
nothing to add, my lord.
So you're content I proceed on that basis?
Yes,
thank you very much. That saves a bit of time.
Thank you, my lord, and thank you, Mr. Pluman. My lord, as you've indicated, you are aware of this case, SBM's case, given that you considered the application to set aside the immediate judgment that SBM obtained last year from Justice Al-Matani in March. Your lordship will recall that SBM's case broadly is twofold. First, a contractual claim against RENISH and Mr. MEHTA in respect of unpaid amounts due and owing under a facility agreement extended by SBM to them. And the second limb is a fraud and conspiracy claim against all three defendants. And I've set that out in my skeleton argument. In light of your lordship's judgment earlier this year, SBM is now in possession of an unimpeachable and final judgment on its contractual claims. But to date, there has been no attempt to pay those sums, nor any indication from SBM that it's going to pay those sums or when it's going to pay them. But the fraud and the conspiracy claims remain outstanding.
Can you just help me on this procedurally? The last time I dealt with this matter was on the set-aside application. At that stage, of course, this trial had been fixed for October against the third defendants, but it was not anticipated then that the first and second defendants would be party to it. That changed, I suppose. I'm not inquiring as to reasons, but you are now hoping to proceed at this trial against the first and second defendants as well. They hadn't served a defence, I think, at the time of the set-aside application. Have they served a defence since then, the first and second defendants?
Yes, there is a signed defence from. I can draw your lordship's attention to it. If you just give me a second to find the reference. That's at page S364.
Right. Well, don't turn it up. I'll find it. Yeah.
And for your lordship's note at S372, you can see that that's now been signed by Mr. MEHTA.
Right. Yeah, thank you.
And in terms of the procedure and the position relating to the first and second defendants, your lordship handed down judgment on the 31st of May.
Yeah.
And it was on the 22nd of June, so approximately 3 weeks later, that the first and second defendants agreed to what I'll call the consent order, setting down directions to trial in October.
Yeah.
And at that time, they gave no indication that they would be unable to comply with that timetable, or there would be any issues of funding difficulties at that time.
Mm-hmm.
In its skeleton argument, SBM's case, Prime states that SBM's case is that all trading between RENISH and Prime were sham transactions that were not performed. That's a paragraph 3.2 of my learned friend's skeleton argument. Yeah. In my submission, that's not a proper reading of the particulars of claim. I don't intend to labour the point, but it's important when we come to consider what the proper test of standard disclosure is. The particulars of claim are at page 172 of Bundle S.
Mm-hmm.
And the first limb of SBM's case in relation to fraud and conspiracy is at paragraph 9,
yeah,
which is on page S175. And that's that Mr. MEHTA, on behalf of RENISH, made various representations. Those representations were that the facility SBM was providing was for bona fide oil trades, and that finally RENISH would repay the whole of that facility.
Yeah.
The second limb of SBM's claim in fraud is at paragraph 12, at page 177. And that is that RENISH sought funds under the facility in relation to specific oil trades. Those are the oil trades between RENISH and Lanka.
Yeah.
So the SBM's case is all about the Lanka sales. It's not about the whole of the trading relationship between RENISH and Prime. And the disclosure provided by Prime has shown that there is, in some respects, an element of ongoing trading between RENISH and Prime, and that's not in doubt. And you can see there, paragraph 12, that's defined as the purported sale. And so the third limb of this fraud and conspiracy claim is then at paragraph 40 at page 182. Which makes very clear that the claim in fraud and deceit relates only to the purported sale as defined as being a sham.
Right.
It's not SBM's case that the whole of the trading relationship was a sham and that every component transaction within that relationship was a sham. And
but it is, okay, yeah, carry on.
And indeed, you recall at the hearing of the immediate judgment set-aside application that SBM were frank that it had had communications with Lanka and it now appeared that there had been contracts entered into between RENISH and Lanka, therefore, i.e. those were actual contracts that existed. But that doesn't change SBM's fundamental case that none of the defendants intended that RENISH would fulfill all of the oil trades within that contract.
Mm-hmm. Yep.
An SBM's case is that it's entirely plausible that individuals and individual companies can have a series of bona fide transactions, but within those transactions can also be fraudulent ones. Indeed, it's often the way that victims of fraud are duped into advancing ever increasing amounts of money, that they are led to believe by way of genuine transactions that the whole arrangement is a genuine one, but there can still be fraud within those arrangements.
Mm-hmm.
But SBM has recognized that the discovery of the Lanka contract has somewhat changed the landscape, and indeed it's written to the defendants seeking their agreement to very minor changes to the particulars of claim to reflect those.
Mm-hmm.
So in my submission, the failure by Prime to appreciate the focus of SBM's case on the purported sale has infected the whole approach to disclosure and the whole approach to the evidence, because Prime's approach seems to be that all it needs to show is a general bona fides trading relationship in order to refute SBM's case, and that's not what the claim is. The claim is that this particular sale was fraudulent and was never intended to be fulfilled.
All right.
So that, in my submission, my lord, sets the scene. That's the foundation from which the approach to the relationship, the approach to disclosure should be conducted. In my letter friend skeleton argument, paragraphs 4 and 5, which for your note is U481-2.
I got it.
There is a series of attacks on SBM's case. In my submission, my lord, the court should ignore those criticisms of SBM's case for the purposes of today's disclosure application.
Mm-hmm.
Today is not the time for an assessment of SBM's case. The trial is 4 weeks away, and in my submission, it would not be appropriate for the court at this juncture to express any view on the relevant merits or demerits of the claim. The merits in my submission are irrelevant to the disclosure application.
Right.
The only live question is whether or not Prime has complied with its obligations of disclosure under the CMC order.
Well, I'm not sure that's the only question, but carry on.
Well,
and it seems to me that you have a procedural problem.
I'll come on to address the procedural problem, but
which is quite a serious one, it seems to me, and it applies equally to the order you seek against the first and second offenders as well.
Well, perhaps, my lord, I can move on to the procedural question.
Yeah.
To deal with that. My lord, there are two relevant orders which need to be addressed. There's the CMC order of Justice Al-Madani, which is at S433, and the second is a consent order, as I say, entered into on the 22nd of June between the first and second defendants, and that's at S444.
Yeah.
For present purposes, the core provision in paragraph 1A of the CMC order and paragraph 1 of the consent order are cast in materially identical terms.
Yeah.
My lord, what the parties were required to do was to give disclosure of documents, standard disclosure of documents by list and category.
Yeah.
Standard disclosure is then defined there.
Yeah.
Now, my lord, that is the test of standard disclosure in the English CPR.
Yeah.
It was agreed at the CMC before Justice Al-Madani
Yeah.
that standard disclosure should apply.
When you say that, okay. And what I've got agreed, or what I've got, I can take it from the consent order because that's the one I've got. That's what I printed out, but it's the same, effectively.
Yeah, my Lord, perhaps it's helpful to look at the schedule of reasons to Justice Al-Matani's order, and that's at S437.
Okay, it's just every time I have to pick up a page, I have to trawl through 100 pages to get there. There's no.
Oh, I'm sorry, my Lord.
Page what?
437.
Yeah.
I mean, Lord, you can see there the reasons why Justice Al-Matani entered the CMC order on the disputed issues, those related to expert evidence and the trial date.
Yeah.
So, in my submission, that supports the instructions I've received, which is that there was no dispute between the parties.
I accept that. But it doesn't provide any proper basis for the present application, it seems to me.
Well, the court identifying having jurisdiction. First, I would suggest that prime submission that the court has no jurisdiction to determine whether or not prime has complied with paragraph 1A of the CMC order, paragraph 1 of the consent order, must be wrong. The court.
I didn't understand prime to be saying I had no jurisdiction to determine question of compliance. I think prime was saying that the rules didn't allow the order presently sought to be made, which is a different point.
Well, my Lord, the question that SBM seeks to be determined at this stage is whether or not the requirement to give standard disclosure of documents has been complied with. And in my submission, one has to grapple with the fact that Justice Al-Madani has made an order that does not neatly fit onto the model of document production provided in RDC Part 28.
Yeah.
As your Lordship is aware, the Part 28 procedure is akin to the IBA rules in arbitration, which requests.
It's familiar to most jurisdictions, apart from, in some respects, the UK and the USA. But
yes, my Lord, and it's an unusual part of the RDC because most of the RDC is a copy and paste of the English Civil Procedure Rules.
Yeah.
But the parties in this case, and all the counsel in this case, before Justice Al-Madani, are all English barristers, and it was agreed that the English test of standard disclosure should be applied. As your Lordship will be aware, under the English CPR, disclosure means identifying documents held in the possession of the parties which go to the issues in dispute. And what then happens is that inspection is then granted of those documents, which means they are handed over to the other parties. Therefore, whereas in the RDC, the first stage is standard production.
Yeah, you produce what you think, what supports your case in broad terms.
So my submission is that standard production of documents in paragraph 28.15 never arose here because what was ordered was standard disclosure. Therefore, the request to produce as envisaged by RDC Part 28.16 and 28.17, which are requests for specifically identified documents by the requesting party to the disclosing party, were never going to be required here, because paragraph 1A of the CMC order requires disclosure to be given at the outset before any requests to produce were provided. So the whole process, the starting point, is not the same as the RDC. Therefore, one has to try and work out how the RDC applies in this particular scenario.
Well, it seems to me that, sorry to cut across you, because I was thinking about it even before I read the Prime's skeleton argument. The terms of the order, which, if you like, go for standard disclosure, replace, or might be argued to replace, 2815. But if there's some defect, some shortcoming in compliance with that, then don't you simply revert to 2816 and 17, and then take it forward from there with the various stages? But you haven't done that.
I agree, my lord, that one could view it in that way. In my submission, that doesn't fit with standard disclosure, because of course by the time one gets to 28.16 and 28.17, the parties have already identified all the documents in their possession. Indeed, the parties went further in this case by following the English model of effectively giving immediate inspection to all the non-privileged documents by sending them with disclosure lists and document production statements to the other parties. So rather than under 28.16, where the parties have only given standard production, i.e. documents on which they rely or documents required to be disclosed by a rule or practice direction or order, the parties have jumped ahead by already giving, on Prime's case, they say, very extensive disclosure and inspection of documents already. But even if that's not right, my lord, 28.16 and 28.17 require the parties to identify the documents that they want to see that haven't been produced.
Yeah.
28.18
in narrow and specific categories.
My lord, well, if one looks at what orders, what the basis for a document production order can be, at 28.36 of the RDC provides that a document production order can be sought on the basis, number 2, that the responding party has failed to carry out a reasonable search for documents which have been requested or otherwise failed without objection to produce such documents which are within its possession, custody, or control. Now, my lord, one has to, unfortunately, again, graft that onto the order that Justice Al-Madani made, which was for standard disclosure searches to be conducted by Prime, and those documents then handed over for inspection unless there was a ground for refusing to do so.
Yes.
So in my submission, and I'll come back to how one deals with requests to produce in a moment, if one looks at the basis upon which your lordship can make a document production order, we plainly fall within 28.362, because what SBM...
So what number was that?
28.36, paragraph 2. Apologies. Yeah. What SBM have been asking for since January this year is for further, in broad terms, is for further searches to be conducted on the basis that we say the searches conducted thus far are not in compliance with standard disclosure as defined in parentheses of the first operative provision of the CMC and the consent order. So in my submission, there's nothing in Prime's submission in its skeleton argument that we're all hobbled by the fact that standard disclosure isn't defined in the RDC. In fact, the word disclosure doesn't feature at all in Part 28. Standard disclosure has been defined in any event in the order. But if one's looking for how the court gets to 28.36, which is the jurisdiction for the party to seek a document production order and the grounds therefore, in my submission, there have already been requests to produce in this case. Rule 28.18 provides that a request to produce should be set out substantially in the form of Schedule A to this part. And Schedule A to Part 28 is a very short provision which effectively indicates that requests to produce should be made in the form of an arbitration Redfern schedule. Requests to produce can be made by letter. letter or in other formats, that there's nothing else in Part 28 which defines what a request to produce must look like.
Yeah.
But if one looks at some of the correspondence on this point, first I can take your lordship to page 513 of Bundle S.
Yeah.
I don't know if it would assist, my lord, but I find on occasion searching for S, T, or U plus the page number sometimes can work in identifying the relevant page.
I can't find a search thing.
Oh, okay. In that letter there, my lord, you can see that Denton's, on behalf of SBM, have written to Eversheds in tabular form, setting out what they say are the deficiencies in the disclosure and making requests for further documentation in respect of the various paragraphs of Prime's document production statement and documents already disclosed. So if one looks at page 514, for example, paragraph 6, one sees there that Denton's is identifying that there are no documents to show key parts of the transaction, such as negotiations between Renish and Prime, the transfer of shipment to Renish, and the cost of freight. Other examples can be found at page 535.
Carry on.
One can see there that's Evershed's response, and that's starting to look much more like a red friend schedule, where you've got their comments and reasons for why documents are or are not there, documents which will be provided, documents which cannot be provided. And then at the bottom of that letter, at 538, we see Prime's own request to SBM in relation to documents. And if you just take number 1, please provide the attached Excel sheet which is sent with this email. So in my submission, there already have been requests to produce. They might not look exactly like a red friend schedule, as might have been anticipated under the IBA rules as adopted in Part 28. But there have been requests made for various documents which each party has said are missing or are not here. Prime itself, in its own skeleton argument, accepts that, but just says that it decided in January this year that it was going to explore the deficiencies of the trial and therefore wasn't going to make an application. That's their choice. But before SBM received my learned friend's skeleton argument, since October last year, there has never been any suggestion that the format of the requests for documents being put forward by SBM were somehow not in compliance with the RDC. Prime did not refuse to disclose documents further documents on the basis that the RDC had not been complied with or that the request to produce had not been in the proper format. And indeed, Prime have made their own requests, adopting effectively the format that Denton's used by way of Evershed's communications. Indeed, my lord, in relation to the additional keyword searches which form the core of this the dispute between the parties, I would emphasise that in January this year, Prime agreed to conduct those searches and repeated the position that it was going to conduct those searches, and in fact was carrying them out in February and March this year.
Yeah.
It did not suggest in correspondence that the form of that request was inappropriate, nor did it suggest that it needed to be put in another way.
Right. And does your present application match category by category what you've asked for in that correspondence?
Well, we asked for the further searches to be conducted, and as I say, it's difficult to map on whether or not there has been compliance with standard disclosure in the English meaning.
I think
a specific request to produce, my lord. But I don't. There is unfortunately.
I think we should get away from English standard disclosure. That may be the basis from which parties proceeded up to a certain point, but we're in the Dubai courts, and the rules of court governing this recovery of documents.
My lord, I accept that, but in my submission, it cannot be appropriate for Prime to ignore or fail to comply with the original searches that it was required to undertake by simply saying, well, you actually need to follow the Part 28 procedure, because that's effectively undermines and undercuts the specific order made by Justice Al-Matani. And in my submission, SBM are entitled to ask the court to enforce its original order. There's never been an application to vary the terms of that order that were agreed by Prime. And in my submission, that Part 28.2, excuse me, I've lost the Part 28.36 already provides a basis upon which a party can seek a document production order, which is that there has not been a reasonable search for documents carried out
Within certain narrowly defined categories and so on, yeah. And it all starts with 28:17, 28:16 and 17. You've got to request particular documents or certain categories narrowly defined.
Well, my submission, there has been a sufficiently narrow category defined, which that emails are searched according to certain keyword terms, because, my lord, the nature of Prime's case is extremely broad. What Prime seek to do is to substantially narrow their defence. What Prime have done is to suggest that the only matter in issue is whether or not they sent certain oil to RENISH over the period between January and August 2018. That is not the only part of their defence. They have put in issue the whole of their relationship with RENISH by relying on this open ledger concept and a continuing line of credit, whereby debits and credit were made against that ledger not only by the supply of oil and the purchase of oil by RENISH, but also by way of RENISH making payments to third parties on their behalf. My lord, if I could take you to one particular paragraph of the pleaded case. At page S223.
S223.
223.
Right. Nearly there. Yeah.
Paragraph 14 and 14.1,
Yeah.
one can see the breadth of the defence. Because on the one hand, it said that RENISH made payments to third parties on behalf of Prime to offset or partially discharge the sums it owed Prime for the supply of petroleum products. But then in the final paragraph of 14.1, which is referring to a particular payment made by RENISH to a third party, being an agent located in Iran, that final sentence there, the transaction did not relate to RENISH's business at all, but was instead a third-party payment. And paragraphs 14.2 through to 14.8 are all said to be examples of third-party payments, seemingly unrelated to the trades between RENISH and Prime.
Yeah.
And indeed, at paragraph 15 and 15.6 in particular, it said that between May 2017 and June 2018, there were a total of $57 million worth of payments by RENISH to Prime.
Mm-hmm.
And Prime's pleaded case is that it's owed, and I'm not sure whether this is pleaded that there's 53 million dirhams owed by RENISH to it. Now, on yesterday's Google conversion, that's about 10.5 million pounds.
Mm-hmm.
On the open ledger system.
Yeah.
And of course, it's RENISH's pleaded case makes no reference to this open ledger, these third-party payments, the open line of credit at all.
Mm-hmm.
RENISH's defence is that there was simply 2 orders made to Prime for the delivery of oil, and that Prime failed to make one of those deliveries to the requisite specification and 3 of those deliveries at all. And therefore it says that it has a claim in damages against Prime for breach of contract. A far more simple case. But you can see the immediate difficulty that SBM is faced with, my lord, which is that we have to grapple with the fact that a defence has been advanced on the basis of a seemingly extremely complicated commercial relationship. And that commercial relationship is said by Prime to prevent it, to pose it a real difficulty, because it says it has no access to any of the documents that RENISH held on its behalf. And it says that there were no formal contracts entered into it. All its correspondence was conducted either over the phone or by email or by WhatsApp informally. And it says that it can't even identify what the starting point of the open ledger was in January 2018. And we're now into our second round of exchange of experts reports about the plausibility, I'll put it that way, of the reconstructed ledger that Mr. Sadr has put together. And there's a joint report from the experts which frankly admits that on the present state of disclosure there is insufficient documentation to substantiate the ledger as put together by Mr. Sadr. So, my lord, it's the case that the entire commercial relationship in this period has been put into issue, but the third parties who were paid, the exchangers that RENISH was meant to have paid monies through, are left entirely unidentified. So, my lord, it's not possible for us to put together extremely narrowly focused requests, focusing on documents that go to particular third-party payments, payments to particular exchangers, payments to particular ultimate suppliers of oil to Prime, because Prime refuses to tell us who they were. So in those circumstances, we're faced with the difficulty that really all we can ask for are search terms which we can put together to the best of our ability, which could capture documents that would either support Prime's case or adversely affect its case. the approach to disclosure is not simply to identify certain trades that were made between January and July 2018. The proper approach to disclosure is to give all documents which go to this trading relationship. So
why do you need to go beyond August 2018?
In my submission, the period beyond August 2018 is relevant because if, as Prime say, they're owed a very substantial amount of money by Prime, in our submission, there should be emails and other correspondence showing it, trying to chase those funds. It's SBM's case, of course, that Prime and is in cahoots, acting in concert with RENISH and MEHTA in relation to the diversion of the funds and the misappropriation of the funds advanced by SBM. Moreover, my lord, SBM would submit that I think it's put by Prime that beyond 2018 to August 2018 would be irrelevant because most of the documents would simply be comments on past conduct and past events. In my submission, those very sorts of comments would be indicative, or as your lordship put it in his immediate judgment, would corroborate inferences of Prime's state of mind before August 2018. Because if there are various emails after August 2018 which demonstrate that Prime was in shock and indicated clearly that it felt it had been the victim of a fraud, well, those would support Prime's case, and I can't. What's the prejudice to them in providing them? But equally, if there are no emails after August 2018 suggesting that Prime felt it was the victim of a fraud or was owed substantial amounts of money, those adversely affect Prime's case that it too was the victim of a fraud. We're in the bizarre scenario, my lord, where effectively we have two defendants, each of which claims it was defrauded by the other, and SBM sitting in the middle.
Yeah. All right.
I don't have any particularly strong preference, my lord, as to who you would prefer that I deal with first, Prime and RENISH, or RENISH and Mr. MEHTA's failure to comply with the consent order, or Prime. I'm happy to take them in either order that you prefer, Lord.
We'll deal with Mr. MEHTA. Them is very short. You want them to comply with the consent order.
Yes, thank you.
But you don't want a defence struck out.
No, my lord. Having taken further advice, you'll recall.
Where does paragraph 1 of your order get you if you don't want the sanction of striking out the defence?
What we would seek is a very short timetable for compliance.
Saying you're already in default in complying, you really must comply.
Yes, my lord, and the appropriate response, if not striking out, would be to seek a contempt application against Mr. RENISH and Mr. MEHTA.
Are there any documents you can identify that you actually want?
Well, we want the searches to be conducted properly.
I'm talking about documents going back to 2817. 2817.
Well, what we would like are all the emails between RENISH and Prime, all the WhatsApps between RENISH and Prime.
Have you asked for that in the order?
Well, my lord, what we're asking for is the compliance with paragraph 1, and I would say that my lord, you can order that under paragraph 28.362.
I'm not sure what power you can order in such general terms. I know Justice Almadani made an order, but he did it on the consent of the parties without it being addressed in argument.
in circumstances where that order mirrored the order argument. Sorry. Yes, I think it was on the basis of an order that he made last October, on which he did hear argument,
right,
and he granted on the merits. But I mean, my lord, if what we're seeking can be distilled into distinct provisions in the order, it's a draft, and if your lordship considers that it would be more appropriate to identify.
Well, the proper course, it seems to me, sorry, going back to our discussion earlier, and I don't want to take up time on it, would be for you to serve a request to produce, identifying particular documents or categories of documents, properly defined, and see what the response is. But it's getting late for that. That would have been the proper course.
And my lord, the response, we already know what the response would be, because we have an email from Mr. MEHTA and RENISH's solicitors, and that's at page. Sorry to ask you to scroll again, but page 6691 of bundle S.
6691.
691, yes, my lord.
691. Yeah, okay. That's not too bad. Right.
Now, my lord, you can see there that at number 1 there,
yeah,
Mr. MEHTA's told AMA, his legal representatives, that the documents disclosed by D1 and D2 on the 1st of July,
yeah,
the entire set of documents. Now, my lord, we say that's entirely inconsistent with what RENISH and Prime said on the 4th of July.
Yeah.
And for your note, that email's at 475.
Mm-hmm.
But to summarise, what they said there is that they were refusing to provide a document production statement on the basis that they would produce that once, and I quote, a full search, end quote, of their documents was completed.
Right.
So in my submission, it's obviously inconsistent to say on the one hand that it was conducting further searches of its documents on the 4th of July, and for it now to say that in fact actually those are all the documents that its clients ever held. And in my submission, I can see what your lordship, I can hear what your lordship is saying about making requests to produce in the format envisaged by 28.17, but I would endorse your lordship's comment about time. And
my comment about time is that you've left it rather late. If you're endorsing that, I agree with you.
I would say that we've not left it particularly. We've not left it too late, and particularly in relation to AMA, because Renish and Mr. MEHTA, too many names. Renish and Mr. MEHTA, because of course the time for compliance with the original consent order was the 4th of July.
Yeah.
And since the 4th of July, we've been in correspondence with them about resolving this issue. And our application was made approximately 1 month after it became clear that there was going to be insufficient compliance. And the reason why there was a compressed timetable was to try and save the trial dates. Of course, it had already been adjourned from February to October. And in light of Council's availability, I suspect that it was going to be many months before any other available trial window could be agreed, or parties would be available for it. So I would say that we're not late in relation to Mr. MEHTA and Renish. And to address the suggestion that an order saying that you're already in breach of an order, here's another order to comply with the order, would be otiose. Well, I would simply draw your lordship's attention to the various authorities that my learned friends have cited in their skeleton argument, the effect of which they say is that an unless order should only be made once every opportunity for compliance with the disclosure order has been made. Yeah. And in my submission, setting up a short timetable for compliance will indicate to Mr. Mehta and RENISH the seriousness of the situation and the need to comply. And of course, if they don't comply, both SBM and Prime can draw that to the court's attention at trial, and if necessary, ask for the necessary inferences to be drawn if that's what they wish to do.
But if you're right, they can already ask for that on the basis of the consent order.
That might be right, but of course, the trial judge may well be reluctant to do that if there's not been a very clear timetable set up for further disclosure or for compliance. But in any event, my lord, the other aspect, the other thing we're asking for is simply a document production statement to be provided. Both SBM and Prime have produced document production statements. It seems to be it's agreed by all the parties that that does need to be produced.
Yes.
And Mr. Mehta has indicated that he's willing to do so. The difficulty we have, my lord, is that since the 4th of July, there has been a glacial movement from Mr. Mehta and RENISH as to the production of a document production statement. And we say that a deadline for that now needs to be set in order that both SBM and Prime can understand the nature of the searches and disclosure undertaken by Mr. Mehta and RENISH.
Yep, okay.
That's all I was going to say on Mr. Mehta and RENISH.
Yep.
Moving on to Prime, as I indicated at the outset, there are now fewer issues in dispute than there were at the outset. My list of the provisions of the draft order that have now, which SBM is no longer pressing for an order in those terms, for your note are 2.1.1, 2.1.2.
So all these are, I see, yeah, 2.1.1, 2.1.2,
2.1.5, 2.3, and 2.4.
yeah.
And you can see my note is at paragraphs 31, 38, and 42 of my learned friends skeleton arguments identify Prime's elements of that draft order, those provisions of the draft order. I may have missed off one relating to searches of Mr. Sada's WhatsApp messages, which I'm sure Mr. Plumman can correct me on if I have missed that.
My lord, I'm sorry to interrupt. It's probably best that we get this right. Paragraph 41 of my learned friend's schedule, skeleton, I beg your pardon.
Give me a second. Yeah.
Says that he seeks. This is the claimant skeleton argument. It wrongly says Prime invites the court. He said the orders are 214, 215, 22, 24, 25, and 26 of the draft order. I understand that to be what he's seeking.
Quite right, Mr. Plumman. Of course, that's a typographical error. It's SBM.
Yes, but my point is that the list there is different from that which remains after excluding the ones which were just listed. So also excluded is 2.1.3, and the skeleton suggests still seeking 2.1.5, although in my view the skeleton elsewhere on the substance concedes that it's been complied with. The skeleton still lists 2.5, which was not listed in the summary just given. So it does seem to me to be necessary to work out what the application is actually for.
Can we just go through, Mr. Hogan, just for my notes, I was marking it quite quickly without reference to paragraph 41 of your skeleton argument.
Yeah.
As I understand it, and as Mr. Plumman can intervene if he thinks I've misunderstood it, you're no longer seeking 2.1.1.
No, my lord.
You're no longer seeking 2.1.2.
No, my lord.
You are seeking 2.1.3.
That's right, my lord.
except you don't mention that in paragraph 41.
That's that's an error on my part. I think the substance of it can be understood from the skeleton argument.
Just for my notes,
Yes.
2.1.4 you are seeking,
Yes.
but not seeking 2.1.5.
No, apologies. That's an error.
You are seeking 2.2.
Yes.
Not 2.3.
No.
Not 2.4.
No.
And what about 2.5? You are seeking that?
Yes, and 2.6.
On 2.6, the whole of.
Yes. Apologies for any confusion.
That's right.
In terms of the substantive application and what's been pressed, those are set out at paragraph 40.
Yeah.
In some detail.
Mr. Pluman, does that give you an indication of what's on the menu?
I see what's on the agenda. I'm taken by surprise in the sense that it seems to be an express departure from paragraph 41 and indeed from, I think, the private correspondence that we had with Miller and Friend, but I'll deal with it in submission on the merits.
Very well, thank you. Yes, Mr. Hogan.
Thank you. And the only additional comment I make in relation to that narrowing of the issues is that, of course, we say that the fact that Mr. Prime has preemptively fulfilled each of those provisions of the draft order rather indicates that they recognised it was inevitable the court, if it has jurisdiction, was going to make those orders.
I'm not helped by that sort of submission. Let's concentrate on the merits of the points rather than getting barbs in the whole time.
I'm grateful. My lord, taking three broad gaps. The first is we say that the manner in which Mr. Sadr has approached the terms of paragraph 1A of the consent order, i.e. standard disclosure as defined in parenthesis in that paragraph, has been insufficient and inadequate, and has been far too narrow. And if I could ask your lordship to turn up at U70.
Yeah. Yeah.
One can see that the first step that Mr. Sadr undertook in relation to identifying responsive documents was that he started by identifying the deals, which we understand to mean oil trades, that had taken place during the relevant period of January and August 2018. In my submission, that's the wrong starting point. The existence or not of specific individual oil trades is not the only pleaded part of Prime's defence. I've already canvassed. Prime has put an issue that trades with RENISH, but also the third-party payments and the open ledger, both of which appear to be denied, or at the very least are not admitted by RENISH and Mr. MEHTA. The terms of the CMC order and the nature of standard disclosure identified there require Prime to identify all documents which might adversely affect its case, which in my submission goes far beyond the identification of specific trades of oil.
Yeah.
Then at paragraph 42, one sees that Mr. Sadr himself then decided to make a list of the documents he expected to see for those sorts of transactions. But again, in my submission, that's not the correct approach. It's not for Mr. Sadder to decide which documents might or might not go to those transactions. What he needed to do was search all the relevant documents and identify.
But Mr. Hogan, surely in carrying out a search, a lay commercial person will bring to bear his own knowledge of what sort of documents you expect. Isn't that what Mr. Sadder is saying?
But that would be fine if they only pleaded defence. There were a series of genuine oil trades, but that's not his defence. Prime's defence is not only that there were genuine oil trades, but that what was also going on was various payments to and from unidentified third parties against which debits and credits were made on an open line of credit. And crucially, Prime say that's why they cannot identify any particular oil trade in respect of which SBM advanced monies under the facility. And of course, my lord, we have a claim, an alternative claim in unjust enrichment, which is that Prime never supplied the oil for which SBM advanced funds. So in my submission, it's not enough for Mr. Sadder simply to identify the documents you would expect to see for the 19 transactions. He has to identify the documents which go to that broader question of the payments to and from third parties via RENISH, which were used to offset the open line of credit that had been advanced.
Yeah, okay.
And indeed, in my opinion, that flawed approach is underlined by that last bit of paragraph 42, which is a list of those documents I expect to see, and intended to also use these documents to reconstruct the ledger. Well, in my submission, that's putting the evidential cart before the production horse, because I can understand that Mr. Sadder would want to identify the documents which would support his evidence. All parties wish to do that, but it's not appropriate for Mr. Sadder to decide that what his evidence is going to be is his attempt to reconstruct the ledger, identify the documents he says he needs for that by reference to 19 transactions, and limit his search for documents on behalf of Prime to those documents. He has to identify all the documents which may be adverse and therefore undermine his construction of the ledger, not just those which would support it or assist him in reconstructing it.
Yeah.
My lord, if I can take you back to bundle S.
Yeah.
And page 675 there.
Yep. I've discovered a way of getting straight to the page.
Oh, great! That's excellent. That means I can speed up. This email we say demonstrates the flawed approach to disclosure undertaken by Mr. Sadder, because this is a document which has been disclosed by Mr. MEHTA.
Yeah.
And you can see that it's an email copied to Mr. Sadder, which relates to an investment in a joint venture.
Yeah.
And we can see there also that it refers to Mr. MEHTA making various requests for information about the RENISH investment, profit and loss, and other financial information. And of course, that cuts directly across Prime's case that it has no access to documents because it was RENISH that held all the financial material relating to their relationship. And of course, also a proper search applying the word MEHTA would have just turned up this document, and it goes directly to the broader commercial relationship between the parties which has been pleaded, as well as the pleaded defence that Prime has no access to information and documents.
Yeah.
The other issue that we take with Prime's approach to disclosure is the manner in which Mr. Sadder has reviewed two email accounts, which I'll call the RP accounts. One is RP operations at primeenergy.me.com, the other one's RP shipping at primeenergyme.com. And what Mr. Sadder appears to have done with those accounts, and this is at paragraphs 22 and 23 of Prime's disclosure production statement.
Where do I find that?
That's it. S510.
Yep.
And what one can see there, my lord, is that Mr. Sadder entered the keyword searches for the relevant period, conducted an initial review of some of those documents before he, quote, noticed that certain of those or all relevant emails were either copied to himself or to the agents. Of course, we don't accept the test of relevancy applied. And he then himself took the view that those emails would be duplicates of the emails already reviewed, and so did not review them further. In our submission, unless Mr. Sadder had deduplication software on a document review platform, he had absolutely no way of telling whether the entire volume of returned emails would or would not be duplicates of the emails already reviewed. That's pure speculation. And at paragraph 24, Mr. Sadder goes on to say that he somehow identified 3 emails in those returns which were not copied to him or the agent, but it's never once been explained how Mr. Sadder was able to identify those 3 emails amongst all the others, when he says that he decided not to review any of the emails after first noticing that certain emails were duplicates.
Mm-hmm.
So in my submission, it's Mr. Sadder has decided for himself that he'll just stop reviewing on an entirely speculative basis. And given that Mr. Prime's case is that these 2 email addresses were used by RENISH to manage all of Prime's day-to-day operations, it's essential that these accounts are properly reviewed for responsive documents.
Mm-hmm.
And for your notes, at page S652 to 660, there are in fact 4 email chains sent to or from those 2 RP addresses, to which neither Mr. Sadder nor the agents were copied. So we have clear evidence that emails have been missed off.
Right.
And just I can take the other bits in slightly more of a canter. In relation to the so-called agents, Mr. Sadder has identified a number of email addresses operated by those agents, primeenergyme.com email addresses.
Mm-hmm.
Those are in a table at paragraph 35 of his third witness statement at page U 507. It's accepted by Prime that it has access to all the email addresses on the primeenergyme.com domain.
Mm-hmm.
But yet Mr. Sadder decided that he wouldn't conduct the relevant searches. He would just delegate those all to the agents. And in our submission, that's totally inappropriate. If Prime has those documents in its possession and control, it should be conducting those reviews itself. Because all we have is Mr. Sadder's word that he orally gave the requisite proper instructions to those agents to conduct the searches. We say that the proper approach was for Prime to review those email addresses itself. In relation to paragraph 2.1.2 and 3 of the draft order.
Sorry, say again.
2.1.2 and 2.1.3 of the draft order.
You're not asking for 2.1.2 anymore.
Sorry, 2.1.3 and 2.4. Sorry, my lord.
Yeah.
We say that it's necessary for Prime to identify the documents, category, type, and subject matter of the documents that these agents hold, because Prime's pleaded case is that it doesn't have all the necessary documents it needs to make good its in the ideal world, to make good its case on the open ledger.
Yeah.
On the basis that RENISH doesn't, all the documents held by RENISH have disappeared. But of course, we know there's a cache of documents held by the agents which would directly relate to transactions involving Iran, which, as far as we understand it, is the prime source of the oil that Prime traded with RENISH. And in order to understand whether or not proper searches have been carried out, we need to know what those documents are. We're told by Prime that those documents relate only to logistical and technical matters. Well, if so, just tell us what they are. If there are not many of them, it can't be very difficult to tell us what they are. And if, as my learned friends say, all the documents held by the agents simply support its case, we can't see any reason why we can't simply be told the category and type of documents held. It's essential for understanding whether or not the case on the inability to reconstruct the ledger properly is a good one.
So you're not asking for, under 2.1.3, you're not asking for any documents, you're asking simply for a description of the type of document.
A witness statement setting out what they are, yes.
Right. Right.
2.145, my learned friend suggests this is duplicate.
You said you weren't pursuing this.
No, 2.5 we are pursuing.
I thought you said 2.1.5. Okay, 2.5. Yeah.
My learned friend says this is duplicative. That's not right, my lord. There are a series of emails which appear to have come from a Yahoo website. Those are at 652 of bundle S.
Yeah. Yeah.
Through to 6.59, and one can see there at the top Yahoo Mail at the very top, and at the bottom of the page mail.yahoo.com/search/keyword.
Yep.
There are only 4 emails which have been disclosed with those words printed on them, and those emails are in a substantively different format from the other emails that have been disclosed.
Mm-hmm.
SBM's case is that, in my submission, the proper inference from particularly those words at the bottom having search and keyword is that Prime has access to a Yahoo mailbox which can and should be searched. Prime says that the email domain of its emails is hosted by Yahoo, which means that in fact it's only been searching its own accounts, but it's never provided any evidence to support, or any substantiation of its evidence to support that, nor has it ever explained why these emails look substantively different in format to all the other emails which it has produced.
Mm-hmm.
And then finally, very quickly, in relation to Mr. Sader's WhatsApp messages having been lost, frankly, I acknowledge that further clarity about this point has been provided by Ms. Massingham's witness statement. However, there are a number of fundamental gaps that remain in the explanation as to how, we say conveniently, Mr. Sader's WhatsApp data was...
Mr. Hogan, you say conveniently. Do you mean dishonestly, or do you mean it is simply happens and it turns out to be convenient? This
happens. Well, I'm not saying it's dishonestly.
Well, then let's leave out the slightly barbed use of conveniently.
But there has never been a proper explanation. We can't know.
That's a better way of putting it. But I thought you had an explanation of why the WhatsApp messages are not available.
Well, we're told there's an explanation, but at paragraph 40.20 of my skeleton, I set out a number of gaps remaining about the case that's been put on the WhatsApp data, and even the most recent explanation about approaching Mr. Del. I'm probably going to pronounce this wrong. I'm sure Mr. Pluman will correct me. Mr. Del is inadequate. There's no explanation as to why he has relevant expertise. We're told he's an expert in vehicle forensics. The assertion that he has expertise in relation to recovering WhatsApp data isn't supported, for example, by a copy of his CV exhibited to Miss Massingham's witness statement. And all this sits slightly uncomfortably with the ever-changing story we had before about Mr. Sadder attending various electronic stores, the Apple store.
Yeah.
So in relation to those outstanding matters, we still seek further clarification in relation to the WhatsApp messages.
And what about 2.6.3? You want to know about their funding?
Yes, my lord.
On what basis can that be relevant?
The worldwide freezing order requires that the source of funds for Mr. Sadder and for Prime's legal fees to be identified. Prime is in breach of the worldwide freezing order for not producing that. And secondly, my lord,
we're talking about relevant and disclosable in this litigation. This aspect of the litigation, not part of the worldwide freezing order.
Impecuniosity is pleaded throughout, is relied on throughout by Prime as to why it can't do various things.
Right.
It can't rely on that if it's not going to substantiate it.
Okay.
I'm conscious of time, and I'll, unless your lordship has any further questions, I'll give way to Mr. Pluman.
Yes, very well. Thank you.
Yes, thank you. Thank you. I'll take it as quickly as I can. Can I just start with one or two general points? The first is as to the scope of disclosure that's required. This is before I even get to the procedural issue. Yeah. What underpins my learned friend's submissions and the whole approach in this application is that what is required for this trial is the full disclosure of all helpful and unhelpful, so including helpful material, necessary to conduct a forensic audit of the relationship between Prime and RENISH. And that is simply not what the issue is. I'll give your lordship the reference to the list of issues. It's at S447. We don't have to go there, but at page 450, issue H, your lordship will see that the focus is on the particular deals pursuant to which SBM made advances to RENISH, and it now appears RENISH in its dealings with Prime paid money to Prime, and ultimately, it is said, SBM was never repaid. And indeed, when my learned friend started, that's actually the point he made. He wanted to stress that it's an attack only on the Lanka deals. But when he comes to disclosure, what he wants to seek is literally everything. He wants to conduct a forensic audit. And that's inappropriate. And one may also wonder why that is so. And we would suggest, but of course your lordship can't decide that at this stage, that the obvious point is a fraud case has been launched against Prime on the flimsiest of bases. And what SBM is seeking to do is to conduct a fishing expedition to see if after the event it can find a proper basis for those allegations. So that's the first point. The second point I was going to make was as to what was sought in this application. I think that's now been clarified. As I say, I was rather misled by the skeleton on paragraph 2.1.3, but I'll deal with it. The third point is the procedural point. We dealt with it in our skeleton from paragraph 14. And really, it is a more profound problem than my learned friend has been prepared to accept. So the case management order was for disclosure akin to standard disclosure, that is, disclosure of documents which are adverse to Prime's case or consistent with SBM's case, confirm SBM's case or undermine Prime's case. And that's been done. Searches were undertaken for a logically defined period from January to August 2018. Those documents were produced. Now, that having been done, the next step had to fall back into the RDC and not into CPR 31. And so there should have been a request to produce. And as your lordship has noted, that would have included in CPR 20, I beg your pardon, in RDC 2817, some fairly narrow and specific details of the documents that are sought. My learned friend sought to say, well, that was done to some extent. And he took you to a letter, the 24th of December, in which a specific document was requested. That was all dealt with in correspondence. That's not the subject of this application. This application concerns two things. It concerns a request for an unless order as to further searches, and secondly, for an unless order as to the provision of information by witness statement. And those things are not provided for in Rule 28 of the RDC rules. We accept, of course, that there is a general case management power in RDC 4.214, but that doesn't change the fact that this application really is procedurally misfounded at the outset. And the fact that Prime may not, in the debate over disclosure, in the correspondence in earlier months, made all of this argument really is nothing to the point. Once the application was to be brought, it had to be brought on a proper basis. I should briefly touch on unless order, but I think I correctly understand my learned friend no longer to be seeking an unless order. It shouldn't ever have been pursued. It was plainly not appropriate. It's addressed in more detail in our skeleton. Can I then turn and take each of the orders which I understand now still to be sought? I do so without prejudice to the general point as to procedural defect in the application and the contention that it ought to be dismissed on that ground alone. The first category is witness statement information, so evidence by witness statement about the agents. And that's paragraphs 2.1.3 and 2.1.4 of the draft order. It is self-evident that the provision of such information by witness statement is no part of RDC 28 at all. The paragraph that was added over and above the skeleton is 2.1.3. So that is a witness statement identifying by category, type, and subject matter what documents the agents, as defined in the disclosure production statement, hold on behalf of Prime and or relating to its business. Well, that wasn't called for under the case management order. Case management order required the disclosure of adverse documents, of documents akin to standard disclosure. And it's not clear on what basis it should be required now. One can see that as a matter of case management, when parties in English litigation are seeking to identify searches which a court might order should be conducted, parties do put up information about the documents that they hold, and they now do it under the disclosure pilot in a very elaborate way. But none of that forms any part of the Dubai rules, and there really is no reason why Prime should have to do that. It's made its disclosure. The second paragraph, which is still persisted in about the agents, is 2.1.4, and it really brings that point rather more to the front, if I can put it that way. So what is sought is information of the documents which have been determined to be irrelevant. Now that would, in my submission, be unprecedented, even in English litigation. By definition, it is seeking something which is outside even the duty of standard disclosure and has no basis at all. So that's the agents. Could I just give you cross references, my lord? That was claimant skeleton paragraph 40.9 and defendant skeleton paragraph 36. Paragraph 2.2 is then an application for an order that Prime now carry out searches of its documents with the search terms and the time period set out at Schedule A to this order, and disclose all relevant documents produced as a result of those searches. Well, there's an issue as to date range, and I'll address that now. There's an issue as to the terms, and I'll come to that. But also,
you mean the search terms?
Yeah, yes, I beg your pardon, the search. Yeah. But leaving those 2 points aside, this seems to be an application that Prime do what it has already done, and there's no reason for that. I will come to the specific email my learned friend has identified and said indicates some inadequacy in the existing searches. It's an email that was produced in the replying witness statement, and which Prime is still investigating, but really was not properly put up as the evidentiary basis of this application at all. Can I pick up first date range? So we've dealt with that at defendant skeleton paragraph 23 and following, and there really is no reason to believe that there are documents after July 2020 which ought to be relevant. It's common ground between the parties.
Do you mean 2020? You said 2020. Do you mean 2018?
Your Lordship's entirely right, and it's my mistake, and indeed I noted it down as July 2020 and read it rather uncritically, 2018. Documents after July 2018. It's common ground between everybody that is when RENISH and Mr. MEHTA disappeared. Mr. Sader has given a whole lot of evidence in his second witness statement about his attempts to track down Mr. MEHTA in July 2018 and about the fact that Mr. MEHTA had then disappeared. Mr. MEHTA has himself explained why he did so and how the business of RENISH had to be closed down from that date. The suggestion that further disclosure should be required after that date is really hopelessly unjustified. I might note SBM's disclosure. And if I could ask you to make a note of this reference, SBM's disclosure production statement is at page S452. And what you would see if you had regard to it is that the date range that SBM applied was the date range to August 2018. Now, I accept that in any litigation, date ranges may be different for different parties depending upon the nature of the case and the issues. But it is nevertheless striking that that struck them as prima facie the right date range. What followed after that was an application for the worldwide freezing order. The suggestion that there will then be relevant documents in Prime's hands after that date has not been adequately evidenced at all. So we say it's just not proportionate to require Prime 5 weeks before trial to start to undertake those searches. It is true to say that in January and February, Prime had said it would have a look at conducting further searches in correspondence in an attempt to be proactive and responsible and get this case to trial. It did do so. But what Mr. Sader explains is he has now found that applying these single search terms to that date range produces a very large number of hits that are simply disproportionate at this stage in circumstances in which there can be no reasonable expectation of any documents to be found. So far as the search terms are concerned, we've dealt with it at paragraph 28 of our skeleton. And what you can see, if you have regard to that, is we've put up a little table that compares the search terms now sought and the search terms previously applied.
Yes.
Bring it up myself. And these search terms have already been applied to the narrower date range, that is the date range to the end of August 2018. Indeed, further search terms as well, so PETROCHEM, Ledger, MAURITIUS, Audit Statement, Lawyer, and NIOC, were previously used and are not sought anymore. And the only additional one is the search term Lanka, but no proper reason is given for why that search term ought to be deployed, and we've set that out in the bottom right-hand corner of the table. Mernfriend prays in aid two sets of emails. The first is the one he took you to at S674, which was the email to somebody called Farbod, or to an email address called Farbod, which seems to have been copied to Mr. Sader. And he says, well, that wasn't produced by Mr. Sader and it must be relevant. It's not clear that it must be relevant at all if one has regard to the email itself. It does not show, contrary to what my learned friend says, that Mr. Mehta is seeking information. It is a reference to some business engagement with Farbod and an attempt to say we must now have a look at profitability and what have you. And that will merit further inquiry. But it was produced, as we say, only in the replying witness statement last Thursday. There's not been an proper opportunity to investigate it. It is not self-evidently relevant in itself. It could not be said that it shows that some fraud is being conducted. And that's really as much as we can at present make of it. It's not the basis for this application. The second set of emails to which my learned friend refers were the RP operations email searches, as to which Mr. Sader had said, well, I determined after searching those two email addresses that I was always copied, and therefore there was no need to review the individual emails further. And my learned friend says, well, there are emails addressed to those email addresses which were not copied to Mr. Sader. What he didn't point out to you is those are emails from SBM itself when it was trying to find out what had happened to its money. So unsurprising, they are not emails between RENISH and Prime discussing the operation of the business. So they really don't take the point any further. That takes me, so that's 2.2. Malunto no longer seeks 2.3. Then as to 2.4, it was in his skeleton, but I think I'm right in saying he's abandoned seeking.
He no longer seeks that. Yeah.
So that takes us to 2.5, which is the Yahoo email boxes. And just to go back to those, they're at page S651, if your lordship can go to the page. I'll just go up to it myself.
Yeah.
Sorry, on this occasion I'm a bit slow. I apologize.
I suddenly learned how to do it.
So if we take the one at page S652, it's a message from somebody at sbmgroup.mu to RP shipping. And then at the top it says Yahoo email.
Yeah.
Mention A. Gupta. Now, my learned friend is quite wrong to say that that suggests the existence of a Yahoo email address. It doesn't. It has self-evidently been accessed in some way on some system that Yahoo Mail provide. But the relevant email address is rpshipping@primeenergyme.com, which is one of the email addresses that was searched and found to be duplicative. So it really, these emails don't support the argument that there is some unsearched email address. Mr. Sader's evidence has been, and it's been explained in correspondence from the outset, that the primeenergyme.com domain is hosted by Yahoo in its small business operation. And however this may have been printed in this form is nothing to the point. There is no Yahoo email address, and that's the end with respect to the application in paragraph 2.5, that there should be a search of Yahoo email boxes. That takes me to paragraph 2.6, which is the suggested information that is sought about the WhatsApp messages. I note again the procedural point. What my learned friend is seeking here is an order that Prime file and serve a witness statement with appropriate documentary evidence exhibited, then setting out all of this information. So it's not a disclosure request. It would have to be a request under the general case management powers. But the full explanation of the loss of the WhatsApp messages has already been given by Mr. Sader, and it is supported by Ms. Massingham's witness statement, which, just to give you the reference, is at U336. And what my learned friend does in paragraph 40.20 of his skeleton is pose some nitpicking questions as to that explanation.
So which paragraph?
In his skeleton, paragraph 40.20. Which is on page 21. And you'll see he says there remain a number of fundamental gaps. There's no explanation as to this. I'll come back to impecuniosity in a moment. Eversheds are said to have reached out to Mr. Del Guisio at Mazars, but it's unclear when this happened. And so on, it's not understood how his forensic background could be relevant. I would have thought it self-evident. It was to get some technical evidence about how WhatsApp messages are stored, and says this is unsubstantiated and so on. So what's Renfrey really doing is he's saying, I'd like to ask some more questions. I'd like to audit the explanation, but there's no basis to reject the explanation that has been given. What is most striking about it is that really what SBM's interest is in whether there is somewhere a backup for the missing WhatsApp messages. And if it is SBM's case that WhatsApp messages are routinely backed up in a WhatsApp server in the United States or somewhere else, access to which is readily available, you would have thought that they would have produced evidence to suggest all of that, but they don't. They ask for an explanation, they're given an explanation, it's an entirely adequate one, and then in the skeleton some nitpicking questions are raised about it. There's no basis for that at all. And then, of course, as your lordship pointed out, the impecuniosity point, so paragraph 2.6.3, setting out how it is funding its legal expenses. Well, that would be an inappropriate order at the best of times. My learned friend says impecuniosity is relied on all over the place. There was a reference to funding difficulties in a letter in, I think, February of this year, but that I think is the only place where there is such a reference. Prime does have a very substantial complaint that its business has been entirely frozen by the freezing order, but that's why it wants to get to trial and get that freezing order discharged. It has not in this application, advanced a defense to paragraph 2.6 of the order that it cannot afford to take steps which might be meaningful in regard to the WhatsApp messages. So this is just a complete red herring. Its case on paragraph 2.6 is that it's given the only explanation that it can give, and those messages aren't available. And as to all of these requests for information, what one sees is Malone friends saying, well, this all seems very unsatisfactory or inconsistent, or this question or that's not clear. Well, that is all properly the matter of cross-examination of Mr. Sader insofar as it has any relevance at all at trial. It is not properly the basis of this application. So for those rather rapidly taken reasons, but supplemented by our written submissions, we would ask your lordship to dismiss the application.
Yes, thank you very much. Can you just give me 1 second? I'm just looking up the case management powers you mentioned in RDC
4.2.
4.2, is it?
And then 14 is the court may take any other step or make any other order for the purposes of managing the case and furthering the overriding objective.
So where's that? 4.14?
No, 4.2 bracket 14.
All right. It's one of those nice provisions. Judges like.
Yeah, indeed. So the court does have a wide case management power.
We used to have the same sort of thing in the commercial court in Scotland as well.
Yes.
Which you could always point to in emergency.
Yes.
Right. Thank you very much then. Mr. Hogan, was there anything, can you just help me on what is said about a Yahoo account, alleged Yahoo email address? There seems to me some force in what Mr. Pluman has said about that, namely that these pages don't indicate the existence of a Yahoo email address. It's simply been accessed on the Yahoo system. Can you help on that?
Yes, yes, my lord. The difficulty we have is that we've been asking correspondents for some time for some sort of substantiation as far as that my instructions are that we want it confirmed. I mean, it's, if the prime domain, which is controlled by Prime and Mr. Sader has access to, it surely must be possible for it to write to the company that hosts that and ask them just to provide a letter confirming that there is no Yahoo email account. The only reason this has come up is because these are emails which have been disclosed by Prime, which look completely different in format, I'm instructed, to the other emails disclosed. So how they've come into being with this particular footer and header is curious. What we're looking for is some explanation as to that, and rather than just having to take Prime's word for it, we consider that we should not be beyond the wit of man for some sort of proper substantiation of the point about hosting to be provided.
I suppose the alternative course is for you to take whatever expert advice is available to you as to how this might happen.
If your lordship isn't minded to make the order sought, I would have thought an alternative was simply just to make an order that some sort of email from the hosting, confirmation from the hosting company is provided. Indeed, if this issue wouldn't have arisen at all if Eversheds had taken the far more economic approach of simply getting some sort of confirmation and sending it to us.
Yes.
Well, may I just say that's not what paragraph 2.5 seeks. Paragraph 2.5 seeks a search of Yahoo email boxes.
Yes, I accept that. I don't disagree with that, Mr. Pluman. But what I understood your lordship's question to be was, if in light of the explanation given, why is 2.5 sought? Well, in the absence of any substantiation that there isn't a Yahoo account, then the order seeks searches of any Yahoo account which is controlled by Prime.
It's rather reversing the burden of proof, you might think.
Yes.
You don't normally start asking for everything on the basis that you haven't been told for certain it doesn't exist.
My Lord, I'm happy to make an oral application now for a requirement that Prime writes to its hosting provider in order to confirm the same. That's an order which can be made by this court under as the magic provision that you've just considering.
But you can make an application if you want, but it will be refused.
Well, I you say.
Well, thank you both very much. Is there anything else you wanted, Mr. Hogan, you hadn't anticipated being said that's not in the skeleton argument or elsewhere?
No, my lord, no surprises.
No, well, thank you very much. Well, I'm going to give my. Do you want? I will give my decision. Then I will ask you whether you want any written reasons to be given. I'm not. As regards the first paragraph of the proposed order, of the draft order, I've already told you. Sorry, start again. I've already given my indication as to how I would rule upon the first and second defendant's application for an adjournment and so on, and that will be part of the order. As regards paragraph 1 of the draft order sought about disclosure, I am prepared to make an order that the first and second defendants serve a document production statement within, I'm going to say, 14 days. But apart from that, I'm not going to make any other order for disclosure. It seems to me that the procedure is wrong. It can't possibly be said that the standard disclosure falls within the terms of 2817, which is the next stage after initial production of documents under the RDC rules. And but it seems to me that I can properly require the serving of a document production statement so that you know where you stand in relation to the first and second defendants' attitude to documents, and they have promised one. So, and that will be within 14 days of today. I'm not of course, going to make it an unless order because that's not sought now. As regards the order against the third defendants, Prime, to refuse to make any order on the application, I think there is force in the procedural points raised. It is unfortunate, I think, that the case started off with parties agreeing to offer disclosure on the English basis, but that having been done, and I can see why it was done, and it may have been helpful, but it seems to have taken people's eye off the ball that the requisite procedure, if initial disclosure is thought to be inadequate, is to proceed under RDC 28, and that should have been done. But rather than rest my decision on a procedural nicety, I would go on to say, if I were giving reasons, that I see no basis, having read the skeleton arguments and the material to which I've been directed, I see no basis for considering that it is appropriate to make an order for disclosure in any of the outstanding categories sought, that is 2.1.3, 2.1.4, 2.2, 2.5, and 2.6. I can, if either party wants reasons for that decision, I can set them out, but I don't imagine that any party does, and if so, it'll take me a day or two to do so. Does either party want a reasoned decision on that?
I'm just taking instructions via WhatsApp.
Lord, not on our account, and the only other thing that we would then ask for is our costs, and there is a costs schedule if we have time to deal with it.
I don't think I've seen the schedule.
It's at, I think it should be at Bundle U, page 504.
Sorry to interrupt, Mr. Pluman, just to take that point. I'm instructed that we would like a note of the reasons for the dismissal of the application.
Right. Very well.
I'm grateful.
It won't be for a couple of days. So
I appreciate that.
Right.
My Lord, I hope you have a schedule.
Yes, I do now. Yeah.
It's either 504 or 505. Mine is unfortunately freestanding, so it doesn't have the page reference on it, but it's a court statement of costs.
With a figure of 440,000.
That's exactly right. That's obviously dirham.
Yep.
Lest your lord think it was pounds.
Does the claimant also have a schedule?
No, the claimant's indication in correspondence, unsolicited, was that if it succeeded, it would seek its costs, but not seek for them to be assessed at this stage. We see no reason for them not to be assessed, and we'd ask for an order for costs in the amount of the schedule.
Mr. Hogan, do you have any comments on the schedule?
I have a submission on the broader question of costs, which is
Yep.
that in relation to those to the narrowed issues, i.e. those parts of the order that we didn't press, in my submission, those parts of the order weren't necessary to be considered by the court in any event, because those had all been complied with in advance, and therefore effectively conceded in advance by Prime, and therefore, regardless of the judgment your lordship has just given, costs shouldn't be allowed on those points, because the fact that they were conceded rather indicated that the Prime did not consider that it would succeed on those. So my submission is that any cost order should take account of the fact that there was preemptive compliance with the draft in advance of the hearing. And had those matters simply been addressed in correspondence, we wouldn't have had to go to the time and trouble of seeking them in the first place.
You're not suggesting the hearing would have been unnecessary, though? In other words, you're not suggesting you wouldn't have pressed for the outstanding matters which hadn't been agreed?
No, but I consider that, but in my submission, it's entirely appropriate for the court still to recognise the fact that on parts of its application, in effect, we have been successful because those provisions were already complied with.
Yes, well, I think the proper approach might, if one takes those into account, would be to assess whether they would have succeeded. And I would need some persuading, but it's inappropriate to go through the arguments on the merits simply to deal with the question of costs. In terms of the itemized schedule, is there any particular feature of it which you say is excessive?
In my submission, the amount of time spent by a partner on correspondence in addition to an associate, and my instructions are that throughout this litigation, almost all correspondence has been between Ms. Flanagan and of Eversheds and Denton's. There hasn't been any emails sent by Ms. Massingham in relation to this application, as far as I'm aware. So the total of 27 hours on correspondence is excessive. Again,
oh yes, yeah.
At the very top of the page, I think attendance on others is at the very top of the next page. It's fallen away. In terms of the work on the documents, 36 hours of associate time, when then added on to 15 hours of partner time, again, is excessive. Mr. Sadder's third witness statement is not extensive. Ms. Massingham's witness statement is short and is effectively an attendance note fleshed out into a witness statement. So again, I would say that total number of hours, going over 40 hours on two relatively short witness statements, is excessive. I would say that I would submit that it's not necessary for Ms. Massingham as a partner to attend this hearing. It's a short procedural interlocutory hearing. It's unnecessary for a partner, an associate, and a trainee. I'm assuming that Ms. Haddad is a trainee solicitor is excessive. And finally, with no disrespect to my learned friend, I would say that it's entirely inappropriate for a Queen's Counsel to have attended this hearing, particularly when supported by a junior who's, if I recall, 10 years call. This is a short disclosure application routinely dealt with by junior counsel. It's entirely unnecessary for Mr. Pluman and Mr. Page to appear collectively together today, and in my submission, entirely inappropriate for Mr. Plewman to attend at all.
My Lord, as to those submissions, very briefly, what my learned friend conveniently ignores is that he was in fact seeking an unless order which would hold the potential to create an opportunity where Prime could be said to have not complied and automatically to have its defence struck out, since the order would then take effect immediately. It was for that reason of immense importance. The fact that my learned friend, in the face of the skeleton, abandoned his request for an unless order doesn't change the fact that I had to be here for that reason.
Yes, very well, thank you. But do you accept, Mr. Plewman, that there is scope for argument about the involvement of a partner and the hours spent by a partner?
No, for the same reason, and she did have to provide a witness statement as well. I do accept that, as always, Your Lordship can look at the schedule and may come to the view that it warrants that any order should be in a slightly lesser amount. But I rather emphasize that the territory we're in is in the territory of slightly, and I don't accept any of the criticisms advanced.
What is the conversion rate, roughly, dirhams to pounds?
It's 4 point something. I think my learned friend had looked it up, but I can't remember, frankly.
I can check now on Google.
Well,
yes, my learned friend's right. That's approximately the right conversion.
4 something, yeah. Well, what I'm going to do, if take a very broad brush approach, which will satisfy no one, is to assess the amount of costs in the sum of 400,000 dirhams. Seems to me that the importance of the application with the threat of an unless order justified the attendance of Queen's Counsel and justified the involvement of partners in the firm. Those being the main contentious issues, it seems to me I should knock off something, but reduce it only to 400,000.
Thank you.
Now, Mr. Hogan, you may want your costs against the first and second defendants, do you? Or you're not going to bother?
Yes, my lord, and we're happy for them to be assessed at the end of trial. That was the approach that we thought was proportionate in light of the time for today.
Well, that was an application, as it were, generally, and was opposed also by Prime. We do in fact have a separate schedule for a very small amount of cost for that, but we would suggest the right order for that application is that costs be payable both to the claimant and to us to be assessed at the end. At the end.
Yes, very well. I'll make an order that the defendants pay the cost of the other parties to be assessed by the registry, if not subsequently agreed, if not agreed. Very well. Thank you both very much for your assistance and for your skeleton argument. I'm sorry we had to start so early. Thank you very much.
Thank you very much, Lord.
Thank you, my lord.
Thank you. Goodbye.